there's another video.
Oh my god, Alexa, why is it only you and me who are shocked by this? Literally nobody else is talking about it.
I almost fell out of bed when I heard that. What do you mean? There's another video from a completely different angle that's only now being shared.
It's not just from a different camera angle. Listen to what AJ said.
A couple of days ago, we're getting yet more videos. Scraps. Piecemeal. We got another Sallyport video just a few days ago. This one showing the Lexus backing into the Sallyport from some exterior camera.
Wait, what? Backing into the Sallyport? Hold your horses. Screech. Rewind. We never ever saw Karen Reid's Lexus being reversed backwards into the Sallyport. If you recall, ADA Lally only ever showed us Karen's Lexus being driven forwards into the Sallyport, not reversed. What's more, when we were watching Lally's forwards driving into the Sallyport footage, we all noted this square pile of snow indicating some other vehicle had already been there before Karen's vehicle was placed there. Was this footage staged after the tow truck driver had already left? I mean, if you're trying to cover something up, then you're not going to want a witness like the tow truck driver standing there watching you do it. This whole scenario now raises questions about the timestamp on this video. Supposedly 3 minutes before Karen Reid's Lexus is driven into the Sallyport forwards. So, I wonder what the timestamp is for the new footage of Karen Reid's Lexus being reversed into the Sallyport from a different camera angle. And at what point does the judge finally say there's so much shady business going on with all of the digital evidence here that she's going to put her foot down and demand metadata? It's the very thing that's in dispute between the defense and the prosecution regarding all of the digital evidence. Why is she acting dumb like she's never entered digital evidence into the court before? Why is she allowing dispute after dispute over the digital evidence when she has the power to stop it in its tracks before it even gets going? While we're on the topic of the judge behaving like a freaking lunatic, let me just point out here, I think I've worked out her ruling patterns. Once this was explained to me by Andrea Burkhart on Alita's channel Legal Bites, I completely understood what pattern to look out for.
Yeah, I wanted to address this real quick because this came up during that final hearing that they had where they gave, made the final rulings before trial. And I had caught that because Judge Cannoni had specifically said, when you object, don't state a basis. You simply say whether you object or not. That's how she wants it done in her courtroom. It's like an extreme version of, no talking objections so that you aren't telling the jury all kinds of stuff through your litigation of the legal issue. But it is quite extreme because normally, yes, you need to state the basis for your objection, even if it's just a simple term, foundation, hearsay. Yeah. I mean, whatever form of the question, whatever the general objection is, you need to state that. She told them specifically not to. And the question is from an appeal standpoint, how is the court supposed to review that? Well, I'll tell you, this is quite a clever move that she's done because in most courts, in most appellate courts, there is going to be a rule that you can affirm the trial court judge on any basis for which the record is adequate to reach that conclusion. And so basically what that means is that say, for example, the state was objecting and they objected on hearsay grounds and the judge sustained that. That could potentially be error if the court looks at it and they're like, well, no, this wasn't offered for the truth or something like that. This was not a basis. So what she's basically doing is she's leaving the door open for the state to go in on appeal and then argue any basis whatsoever to justify this objection. And if that is arguable, if that would have been within the trial court's discretion to sustain that objection, then they'll affirm it because they can do that for any reason. They can't reverse for any reason on the record, but they can affirm for any reason on the record. So it's just a little clever way of taking advantage of that procedural kind of preference that the judge gets in making those types of rulings.
Yeah, that's really interesting. I hadn't thought about that aspect. I just got as far as she's trying to prevent snide bars like what we saw in the Hannah Gutierrez Reed trial. It's a little bit sneaky, and it does seem to be a self-protective move by the judge when you explain it that way.
Mm-hmm.
Interesting.
With that in mind, that Judge Bev will only make rulings that will be affirmed by a higher court rather than reversed, you can now start to predict how she's going to rule on nearly all the pre-trial motions. In the case of Dr. Russell, for example, I predicted that she would allow the Dalbert hearing to go ahead, since there is a scientific question mark over dog bite dentition. And if Dr. Russell even remotely looked like she was going in that direction, then she could make a ruling that would ultimately be in the benefit of the Commonwealth at appeals. Similarly, I predicted that she probably wouldn't have a Dalbert hearing for Mr. Green, since she would be wading into reversible error territory, given that digital forensics is an established science and there are no question marks over that. You may also note that she takes shortcuts, where she doesn't give any basis or reasoning for her decision in order to avoid being reversed by a higher court. And then, when she thinks that there's a much higher chance that she could be reversed and found in error, she will provide some type of reasoning. Some might argue that that's what all judges do, and in essence I would agree. However, not all judges allow evidence to be entered into the court record without proof of chain of custody. Not all judges allow dispute after dispute to arise between the defence and the prosecution over digital evidence without first ordering the metadata for that digital evidence to be entered on record before even discussing that evidence. I could be here for days listing all the things that Judge Beverly Canoni does that's different to other judges. Let's just say, we've all seen how biased this judge is against the defendant in this case. So when you put her obvious bias together with all these little tricks that she plays to give herself plausible deniability, as well as giving the Commonwealth every opportunity to argue whatever the hell they want at appeals, then you'll see the same pattern that I'm seeing, which Andrea Burkhardt obviously picked up very early in the piece. Anyway, aside of pointing out that the judge is becoming more and more predictable in her rulings, and that this new video that has suddenly appeared out of nowhere is showing Karen Reid's vehicle being reversed into the Sallyport, not driven in forwards, let me close out by saying everybody head over to Alexa's channel and watch her video on this particular topic. I'll leave a link in the description so you can go and watch that while I make the next mashup. We'll see you soon.